Hi, everybody. We're back here with the Behring Co and our EB-5 channel, and we have a pretty big update. We just got a new GAO report released in March of 2023, and it is giving us a whole lot of news that we did not have access to before. So I'm Colin Behring, CEO of Behring Co, and I'm gathered with Greg Sheehan, at also one of our executives, and our deepest insights into USCIS and how they work. Greg, why don't you just kind of take us through, one, a little bit about why you know so much about these reports, but then what it is and why it matters to us.
Yeah, so sure. The GAO is essentially, they put this report together to report to Congress how IPO is doing based on the questions that Congress tends to raise, getting feedback from investors, from their constituents, from, wherever the comments come from. Congress is responsible for running a good program within the IPO. So from time to time, they will release the GAO as kind of a third party, almost auditor, to come in and look at the processes that are in place, to look at whether or not there's fraud in the program, what needs to be done about it, how it's measured, what conclusions can be made, and how to move forward. I'm familiar with this because I offered to be interviewed by the GAO when I was at IPO. So I'm almost a co-author of this, but no, they really did a good job talking to a lot of people, going into the weeds. This is some inside baseball. This is also a product that is not sensitive. The sensitive information that was provided to Congress with the initial report in December is withdrawn. So there's some gaps to be filled in here, but overall, the bottom line here is that they were looking for more data collection from IPO about fraud trends and about numbers and how that lines up with their expectations. What are they hearing? Because if you don't have the numbers and trends, the question is, how do you properly address it? What tools can Congress provide to IPO in the future when they inevitably say, we need more help? Well, if you were to drill down and look at Cisna's hearing in front of Grassley saying we need more help, Grassley said, why do you need more help? You're in charge of this. You should be doing it. But to the extent that this is such a robust product line for the United States economy, you've really got to be able to get into the weeds and make sure that you're moving things the right way, especially when it comes to things like fraud and national security.
Gotcha. So a GAO report, is this something that's instigated by Congress? Like, who releases or sends them out to start these reviews?
Yeah, that's a good question. It tends to be an ongoing thing. And if you look at some of the language that's in here, they came out to IPO a few years ago with recommendations based on the relationship they have between Congress and the executive branch. They gave them recommendations. They circled back and they said, have you done our recommendations? What have you done successfully? What is still outstanding? And I think what is still outstanding is that there's some data capture that leaves a little bit more to be imagined in terms of how efficiently the program can be run.
Right. And it's interesting that you mentioned that. And here I'm bringing up on the screen for the GAO report. And this is actually the published version that Greg mentioned, where it is, I guess, somewhat of a redacted version of what Congress really got. Is that correct?
Yep, absolutely.
Yeah. So immediately, this thing is pointing toward fraud as well as national security risk. So I'm guessing that's the parts that we're seeing redacted and kind of taken away from the public eye. Hopefully for good reasons. And ultimately, then the GAO, not only do they talk about fraud and national security, but they do actually give some great general statistics and items and information that was not available to public before, but now gives us a little bit of insight of what USCIS has been up to. So they gave us a little bit of background. And, Greg, what years were you at USCIS, and what was your timeframes there? And what did you experience personally versus taking in through data?
Yeah, so I started there in January 2018 and I left in July of 2022. So a lot of this report is focused on that timeline, and some of the trends that I've seen are directly related to what you'll see here, which is an increase in adjudicators in 2018 into 2019, and then a drop off for policy reasons and attrition. COVID happened, furlough notices, the disaster, right? So that's correlative to what you're seeing in terms of adjudication, processing time, and efficiency. The more adjudicators you have, the more fraud tips you're going to be generating as people go through these adjudications. And If you see that there's more adjudications done, you're going to see that there's more fraud referrals. If there's less adjudications, there's less referrals. It's really more elastic between the two. If you were to split it by country, it's really not helpful unless you're trying to make an inference that there's some type of policy influence, depending on where people are coming from. You could get back into that, without getting into FDNS, which is fraud detection, national security. So yeah, I would say that a lot of this lines up with my experience in terms of specifically the range of adjudications going up and then coming right down.
Got it. Yeah. So that being the case, also with FDNS and like the level of kind of this report coming out and potentially being called on by Congress, go check this out. They were originally out there 2015, 2016. That's when we had a lot of political intervention where certain people were complaining about the program being rife with fraud, rife with national security issues. And apparently this report sheds a lot of light on that, on exactly what they found. And not only did they pour through these interviews that were with the adjudicators, with the economists, and we'll talk about more about the nuts and bolts of who was interviewed and how many of them, but also kind of what USCIS didn't find. What the GAO did not find at USCIS, because there was a couple things that were revealed that USCIS doesn't even track certain data that you would think would be important to the program. And that kind of thing was revealed, and also made a couple recommendations to Congress and USCIS on things that could be fixed. But the recommendations made, which we'll talk about what they are, they can be rejected and or not fulfilled, I guess. USCIS can just not do such things, like the actual cost study of where money goes at USCIS. That was one item that was rejected from the 2015-2016 recommendations, which went unfulfilled. And even today, I believe there's FOIA requests, the Freedom of Information Acts, where people want that data too. So will be interesting to see. But looking at the petition filing statistics, this is actually a good thing. A lot of investors really want to know, do I go with a regional center or do I go direct? And what the GAO found is that over 93% of all these petitions from the 2016 to 2021, these are all fiscal years, by the way, so it's all government. 2016 to 2021, 93% were all regional center petitions. And then, from there, they give you the country breakdowns. And this is largely representative of retrogression. So when they had backlogs, so we had extreme volumes out of China in the 2015, 2016. And then after those dates really started to set in and people really knew how many filings were out there, the estimated retrogression for China was anywhere from 8, then 10, and then as bad as 14 years for backlogs. That's where you saw the number of Chinese filings start to drop off significantly, 2018 and 19, to nearly nothing thereafter. And you saw the other countries really start to contribute. They started to participate a lot more. Frankly, in our experience, we were very, very heavy with Indian and Vietnamese filings from 2018 on. So this makes a lot of sense to us. And the fact that Chinese filings were still there in 2018 is even a bit surprising alone. And today, some of those backlogs are still being felt by individuals that filed pre-RIA and don't have access to the set-aside visas. So interesting stats, but 93% of all EB-5 filings belong to regional centers. And Greg, with your experience looking between directs and regional centers, what are the couple reasons you think that people do that?
There's a lot of safety in the job creation already being built where, no matter how savvy you are at being able to manage a business or think about yourself as an entrepreneur, there's a lot less headache when somebody else is already creating the product for you. Full-time developers, banks are involved. You've got everything already squared away, mapped out. You can pick and choose who you want to work with, and many regional centers are offering products with the job creation already done. When it's already confirmed by USCIS, then the individual petitioner is left to present a lawful source of funds and show that they are actively in the process of investing or have invested the full amount to a qualifying project. That leaves you to just move forward with only your source of funds presentation, which is still a little bit tricky. But when you don't have to worry about job creation, It's a much easier process for you as an individual. If you think about what you have to do to get from A to B, it's a lot easier to just drop your finances into a bucket and walk away than try to manage something. And people have made the mistake of thinking they know better than the government. They can manage a business, they can make money. They've done it all their lives. But at some point, when there's some type of uncertainty in the economy or in the business model that they're driving forward, they may be collecting profit, but not sustaining, creating jobs, and not meeting the extra level of the extra level that USCIS requires. Is not just that you're profitable and supporting the economy, but you have to create and sustain these jobs. So if you get into a position where you're making a bunch of money, you're happy, you're taking home a good paycheck, and then all of a sudden you get this letter, it's an RFE that says, hey, good job, business looks good, source of funds looks good, but you have not created the required amount of jobs. Now your clock starts ticking to have to go or do something else. And now you're trying to get out of a project where you don't want it anymore. Your money's tied up. You've just put your family's immigration future at risk. And you probably relied on an attorney who said, no, it's no problem, I'll help you, with minimal EB-5 experience. The people with the highest volume of EB-5 tend to be regional center attorneys. They get to a point where they're established attorneys, they work with regional centers, that's their bread and butter. A lot of the attorneys who are on the outside looking in that don't have significant EB-5 experience end up taking on the directs also. There's a mix, they're not all like that, but as an adjudicator, you can see very quickly whether or not there's a good presentation or not. And a lot of direct investments are not well presented.
Understood. Okay, so what we did learn from this report is that, when we're looking at fraud and issues of national security, this report was supposed to kind of give a conclusion on, how rife with fraud is the EB-5 program. The general answers here that we got out of this report is that 3% of petitions are even remotely looked at for fraud and issues of national security, meaning that a case was created. When a case is created, tell us what that means versus, something is actually like convicted and or finalized. How often do people just open cases and nothing happens?
Yeah, so it really depends on what's found in the file. The project may be implicated for something that needs further review. The regional Senate principals are usually vetted on a frequent basis. And sometimes if something needs to be reconsidered, it's not going to affect the individual petitioner's chance of approval. So if the jobs are created, but we need to remove a principal, then the applicant can still move forward with their petition. So there's different really components of whether or not the fraud found at the project and principal level would ever impact the petitioner. The economic failure of the business isn't necessarily fraud either, but it's really problematic, especially if the job creation for some reason fails and now the petitioner is headed out the door. So if you look at the denial rates, what we're looking at, Colin, is a mixture of all the potential reasons why there could be a problem. It could be economic failure. It could be a project that never gets anywhere. It can be a bad actor. It can be a principal who's up to no good or who's facing SEC charges. It can be the individual petitioner's source of funds and potential connections that they might have to a national security concern. It could be the spending. If the spending is problematic for CFI US, as mentioned in here, that could be a reason why there's a further investigation needed. There's all kinds of reasons why an adjudication can just stop in its tracks, and there's several buckets. Whether it's national security or fraud or inconsistency, it's really kind of all goes into one hodgepodge where the communication that you have depends on what you're actually seeing. National security tends to be the rarest because you're rarely going to see somebody giving you information that's a national security concern within their filing. So for an adjudicator to actually sniff that out and have it go somewhere, I would say is rare. It does happen. There's training. There's things that you're supposed to look for. If there's something obvious on your plate, you're going to act on it. It just doesn't happen that much.
Right.
With some educated vetting, you can actually get more information and further that process along. It may not eventually go into the national security pile, but extended review is something you could initiate as an adjudicator. For fraud to actually be found, you need to have the person make a misrepresentation or somebody who's trying to fool the system is fraud. An inconsistent benefit request where the information just doesn't line up with prior ports of entry or information provided, that's going to make you not credible. If you said that you're a tourist and you make $500K a year and that's your compelling reason to return to your home country, and now I see the filing and you show me that your income is 100K, that's just inconsistent. I don't know if that's fraud or not. I don't have the skill set to kick you out of the country forever based on that inconsistency. So would I referred for fraud? Maybe. And then FD&S is going to say, I don't have enough information to know if this person was actually trying to fraud the consular officer, but it doesn't look good, right? Is it fraud? Not necessarily. So it really, you get in the weeds when it comes to trying to find out what actually reaches that level of fraud, where most of it is just problems with internal and external consistency.
Got it. Okay. So one of the other statistics that the GAO report gave us is that they found that over 481 regional centers were terminated during the fiscal years 2016 to 2021. What was a lot of the reasons that you guys saw for that happening?
Basically, I mean, the slam dunk termination is inactivity. You registered as a regional center. You tried to go find a project. You tried to introduce capital to it. You just couldn't do it. Your fundraising just never got anywhere. That type of inactivity it's an invitation for a conversation with the USCIS official to say, what are you even doing here? You're not raising capital. It's time to go, and we're going to terminate you. And then you give them a chance to respond to the notice of intent to terminate. And usually they'll just withdraw, like, yeah, it's true. I tried. I couldn't do it. I'm not fundraising. And before COVID, there's not really an excuse. During COVID, well, you should be able to give these regional centers, like, you take your foot off the neck a little bit, because they didn't control what's happening here, right? But these terminations were mostly before that. Failure to promote economic growth would be the reason for termination. And then also inactivity in terms of just not putting in your annual filings. You're going to get a letter from us saying, where are you at? They might say, sorry, we forgot. We're better than that. And they might be able to come back into compliance, and that's okay. But with, I would say, the vast majority of those plus 400 terminations that, when I was involved, you're just taking data and you're looking at the low hanging fruit, and you're sending out letters en masse, and you're getting responses, and you're taking actions on them. And the ones who want to continue to play, you have an opportunity to tell you about why they should be allowed to.
Yeah. And so as an entrepreneur and anybody that's just taking the risk of, putting these deals together, spending significant time and resources to go get a regional center approved, to get certified and get that document, then, have the market kind of work against you, or, in some cases, some countries cut you out with the agents that have picked their winners and they don't want to work with somebody new. Why would USCIS be motivated to just flat out terminate somebody for that inactivity rather than just letting these regional centers exist? Like, what is the logic behind just terminating somebody for not being active?
Yeah, I mean, realistically, if someone's inactive and they're paying you every year to review their forms with zeros on it, but they're still, if they're still in the process of actually trying to do things, then I think that would be part of their response to you, right? Like, we're not one of the favorites of the agents. We need to work on how to figure this out. We're trying to compete. We're actively doing this. And here's XYZ evidence supporting my narrative. And you give me that in a credible way. If somebody goes a year without fundraising, you're not going to get terminated. But if you're looking at 4, 5, 6, 7 years, like, that's where we would start. 7 years and you haven't done anything. Why are you here? We're going to terminate you. Why do you have to terminate somebody? I've heard different arguments. For me, I don't think that 7 years of inactivity means you're going to be inactive forever, right? Like, you could turn a corner. You could just be looking around different products. You're shut out here, you're shut out there. It takes you a while to do it. I think probably these notices of intent to terminate caught people off guard for that reason too, because it was a new policy to actually go And believe me, the industry all found out at once on the same day. They all got the notice of intent to terminate, and they're talking and they're going, what's up? What? We didn't know this was going to happen, because otherwise the notices of intent to terminate would go out for other reasons and not necessarily just to, some technical implementation that we could pull out for efficiency's sake. So yeah, it at least getting the notice of intent to terminate at least allows you to have a conversation with us. Most people would just withdraw and be like, yeah, this isn't going anywhere. It's not for me. And then there were ones who were able to say, like, look, this is actually the steps we're taking this year. Many would just give you a narrative with no supporting evidence. That's hard to take if you've just got a notice of intent to terminate and all you're doing is like writing a one-page narrative. It's not very good. But for the ones that are actually developing networks, you've got contracts overseas, you've got representatives now, you've got leads, and you're actually able to support your narrative with that type of evidence, you're probably going to be able to save yourself from a termination for another couple of years.
Right. Okay. So USCIS gave us a whole bunch of statistics here in a full table. It's on page 23, where it starts discussing the actual filing statistics, and it starts talking about what petitions came from what countries. So when, for investors, when they ask, how many petitions come from which country, who's the most active, is this really just a Chinese program? Is it just a Vietnamese program? What are the compositions here of who uses EB-5? And as we discussed, like, you can look at the whole numbers from 2016 to 2021, and somebody might actually make that inference that very, very much there was a lot of Chinese involvement. And if you do the rough breakdown here, where you've got nearly 40,000 petitions, 30,000 of the approved ones out of 40,000, about 75% of approved petitions did come from China. Then if you're looking at the total adjudications, that number is actually just barely less than the 75% number, but it holds pretty tight. On the approval side, where you say the percent that was adjudicated but denied, it only made up about 12.6% of petitions being denied. The approval rate there, you'd call it a flat 88%. But, Greg, can you give us some insight where, like, how many of these petitions that are denied, that 12.6%, how many of them really just belong to a handful of projects where, a couple big projects fail? Does that tilt the numbers quite a bit?
Yeah, something else to keep in mind. This is based on adjudications during this time period. So these filings are significantly behind the adjudication time. For instance, in 2020, there's not many Chinese adjudications happening. And if they are, they were filed probably at least 5 years earlier. So the filings that came in, which was trickled off for China, but there's a lot of adjudications since 2015, since the 2015 filing date, that haven't been adjudicated. So this number is not as comprehensive as it may look. So I'll just throw that out there. So there's two things that are going to influence an approval or denial. If you have a project like JPEAK, job creation is not there. You're just going through the whole thing and everybody's in trouble. The RAA has actually provided us, thankfully, with language where if you have a project that didn't do well, then the investor can actually get their investment amount up to $800K and continue to move forward. That's really nice. But before that, when it didn't happen, the project could, it's out of the petitioner's control, especially if they're working with an agent overseas. The agent's not calling them back. This project's failed.
Yeah.
Bad, right? Other denials are based on source of funds issues. And I think this comes down to agents who are probably getting involved with fooling their investors into thinking that they're experts at the source of funds presentation at USCIS. And if you have a certain agent who's just doing things the wrong way, then all of their clients are going to be looked at a little bit closer. So I think it all comes down actually to agents. Really, they're not helpful in terms of getting the investors money to be in part of a project that's actually good. And then if they're pushing together their paperwork in a way that's just fraudulent, or even at least inconsistent, that's going to lead to termination on the basis of inconsistency, that's going to be a problem for their client base.
Yeah. Okay. And then like some of the other numbers that jump out here, which are the ones that are not surprising to you? And then which ones are surprising to you?
Iran is not surprising just because of the lack of, central currency regulations. Hawala is what I'm trying to get at. So when you're using off the book currency transfers, and now USCIS wants to see the path of funds and you don't have it, that's a problem. It's really tough to overcome that. And I would say that, further down, these aren't the only countries that use Hawala. And if you were to look at other reasons for, if you were to look at other reasons for denial in similar areas that rely on Hawala, the source of funds issue is going to lead to a higher denial rate as well. I would say,
is that a path of funds break? Like what does it?
It's underground. It's underground currency trading. It's pretty complex. It's just you're not using the banking systems that we are so used to seeing in the Western culture. So if you don't have proof that the money went from one place to another and you have a break in the path of funds, then that opens the door for malfeasance. And we're just not built that way to look the other way when we see gaps, right? So the United States government is going to have a hard time approving cases where there's a break in currency.
Okay. So I look at these tables, and one of the things that I see right away is you see a vast disparity where the numbers jump and fall and plummet in some cases, and then they skyrocket in others, depending on the country. Does that tell you that there has to be a discrepancy really only at the investor level where that would be source of funds, not the projects? Because otherwise these would all be the same numbers.
I guess the nuance here is that different countries have different problems when it comes to sourcing money. China, as we know, they're smurfing friends and family 50K at a time. Going, you're going to see China mainland to Hong Kong. You're switching bank accounts with people. You do that 15 to 20 times now. And that's allowable. But if I'm looking at a country like Russia, okay, Russia's more in the news now than it was before. But the question is, how did you earn the money? What's for a USCIS adjudicator to look into Russian websites, it becomes difficult to verify the information sometimes. It's not open source. You can't always see these companies' registrations. Sometimes you can, but trying to find out whether or not to believe the investor's story because you have a reason to question it, it's harder to go into these countries and figure out information about them and about these people, especially if they're coming at you with significant earnings, right? You want to be able to find it. And based on it's just a matter of being able to get the information that you want. Currency transfers, like I mentioned, path of funds breaks are going to be more common in certain countries than others. If you have a project where you've got an agent to raise capital for a bad project, they're probably all coming from the same agent's country, right? So, that with China being so big, the aggregate's going to wash things like that out. I'm trying to figure out if there's,
the correlation that I was trying to see if there was any, if you thought there was actually any merit to it, was that if the projects were problems, and I guess actually statistically, you could probably fudge these numbers pretty good because certain projects are probably certain country heavy, depending on who was raising.
Exactly.
If you have a Chinese sponsor, they're probably getting most of the investment from China. But if all things being equal, these denied percentages would all be the same if it was a project problem. If it was a source of funds problem, they'd bounce all over the place based on the difficulty of source of funds, as in Iran, Russia, and even Mexico in there. Like I see that at 26.4%. What do you think of the story is there?
Yeah, I mean, that's a good question. I was going to say, you asked what would surprise me, Mexico. I if I was going to pick up a Mexican application, I don't know where I would start in terms of trying to find a credibility concern or a fraud issue based on what I know about the country conditions. I know that there's a lot of wealth in Mexico that's dirty. Like, who doesn't know that? But looking at the file itself, that's not a reason to just say, I don't like how this looks to me. The preconceived notions that you have about, illegal activity shouldn't come into what you're looking at when it comes to how the presentation is made to you. I don't know, why that number is so high, but again, it's not a lot of filings. It could be a series of investors.
That's 5 years too, to only have 251 approvals over 5 years.
Right. 90 denials. It could be 2 attorneys that just picked up and don't know what they're doing with EB-5. Like when the number's that small, it's tough to get a lot from that data.
Yeah, no, it's surprising in its entirety just to have a number that small for some of these countries where you think there would be significant interest in the EB-5 program over the other options. But I guess as in your experience, have you seen, is Mexico like a big E2 country? Like what are the alternatives that you'd probably see instead of an EB-5?
I mean, a lot of people from the southern border have access geographically to get here. They've got family members, so a B1, B2 is a lot more reasonable. A TN visa to come in and work is very, very common for Mexican nationals. So for EB-5 to be an option, it's kind of rare too. Plus earning power in Mexico, it's nothing like China. You saw the real estate in China just go 25x in some places. So people who bought something for $400K now are sitting on a $2 million property. And that happens a lot in certain parts of China. And that's why they were able to access the program. Like that is not happening in Mexico.
Right. Okay. So here's another story that's good for the RIA. So with the new policy for the RIA, we had the introduction of concurrent filing for the EB-5 program. So what we're seeing here, Greg, it talks about the number of admissions either through the I-485 adjustment of status or the consular processing. Can you take us through, kind of what this looks like historically for you?
Yeah, I mean, if you're looking at 15 to 20% of people doing adjustment of status, these are people who are here in an F1 here on different types of visas who are willing to wait while because they can't file concurrently, they need to be able to do something else. They're not going to get the benefit of an EAD because they're pending a 485. Historically, the 526 needs to get approved, and then you file for the 485 and you can get your EAD while you wait. So I think this data is pretty consistent with what I've seen. Most people are waiting overseas for the 526 to be approved. I think the RIA has changed that game as we've seen so much activity, especially on our end. People that want the concurrent filing, get the EAD, they're going to be able to participate in the economy in, let's say, 100 days. Even if it's 6 to 8 months, future retrogression is not going to impair their ability to stay here and participate in the economy in the biggest way possible, essentially stepping in the shoes of a permanent resident. I think this number is going to get closer to 30% domestic filers. I don't know. We don't have.
I don't know, Greg. So yeah, let's talk about what are your predictions? Like, what does this chart look like representing 2022, 2023, 2024? Will this chart look the same in its proportion? And also, you have a different story here of 2016 versus 21. 2016, this largely represents who was filing. And when you had a massive chunk of Chinese filers in 2016, not all of them were F1s, H1Bs, and things like that were in the United States. These were people that were doing consular process. They were outside the country.
Right.
Then as you saw China really kind of start to drop off and fall out of the mix, Vietnam is kind of in a similar boat, South Korea. You saw the proportion, or actually call it the gross number of adjustment of status, I-485s kind of hang on there. You just saw the ones that were doing consular processing disappear, which I think shows you those statistics of what the country of origins were doing. But today, RIA, you don't need to wait for your I-526 approval to file your concurrent filing for the adjustment of status and all that kind of stuff. So what will 22 is behind us, but 2023 and 24, are you going to see that light blue bar just command this graph, or what do you think is going to happen?
So first of all, you want to know how many visas are going to get used. And I don't know if it's going to hit 10,000, but it should be. Well, first of all, there's carryover too. They can adjudicate up to 13,000 based on our conversation with Charlie. They've accepted 980 filings. If you take off 10% for denials, let's say, then multiply that number by 4.3 for family size, and then take it across the 12-month period. I just don't think that you're going to get up to 10,000 approvals. And this year, you're not going to see any adjudications based on concurrent filing, right? Because they're so new, USCIS hasn't got to them. So I don't think 2022 or 3 is the year that we're going to see the light blue take over. But in the future, I think it's just going to get bigger and bigger over time as adjudications trickle down. Then you're going to have restrictions on a country cap. India is probably going to be facing a restriction where they have so many adjustments that they can take in a given year. I think the real question is how much activity is still overseas? How much are we seeing from the market? We don't know how many people are still looking to dump in 800K over time. I think the 14 years of inactivity probably delivered some pent up demand. So early filings, people who were ready to commit the capital did quickly. I just don't know what that trend is going to look like long term.
Right. So here's kind of a wild prediction, but tell me if there is some mathematical merit to this. I believe 2024, and perhaps maybe it's the year of 2025 being registered with, the actual visas issued and things like that. I think it's possible that, let's say 70% or more will all be concurrent filing, and it will be adjustment of status. And that, I would say 75% or more, maybe 80%. You could even go as atrocious as something like 90, but it depends, because what if the word gets out that if you're filing from outside the country, you are going to be exposed to retrogression, and everybody is going to be exposed to retrogression, but anyone filing from inside the country has immediate access to an EAD and a travel permits no matter what. So the word's out that you're not going to be able to live and work here if you file from outside the country.
Well, yeah. So a lot of what our people are doing when we're talking to like KLD and Wolfstorf is they're talking to these guys about how to enter the country with the dual intent visa to be able to capture the presence here, to be able to file concurrently in a lawful way, because they're not going to enter on a B1 visa and then just wait and then try it. If people are here and they change their mind, that's one thing. But when you're developing your strategy, there's other opportunities that are available. If you can afford 800K, you can do an E2 visa. And now if you're from India and you have to go through Granada first, like there are situations where it's not as easy. It's for E2, but if you qualify for an H or an L or an O and you can do it that way, it's going to give you the opportunity to choose concurrent filing as your avenue forward. Yeah,
no, I believe it. So let's go ahead and take a look at some of the other numbers that we were able to pull out of here. Just very quickly kind of rolling through some of the things that we were able to pull. Just wanting to take a look. We found, there were 71 countries that submitted at least 10 petitions. So outside of that, maybe there was some one-offs, but 71, substantial contributors for, who's participating. Then, USCIS is also talking about that there were, 1,500 to 2,000 admissions through adjustment of status. Is that going to include derivatives?
Yeah.
Or is that, okay, go ahead.
Yes.
Okay. So theoretically, if there's like 1,500 to 2,000 adjustment of status, like there's really only 25 to 30% are actual filings. Like what's that number there that you saw?
Family size, based on the numbers that were here, I deduced a family size of 4.3. So if you divide 2,000 by 4.3, and you're looking at about 450 filings.
Got it. Yeah. So it's really not that high of a gross number considering how impactful the program is.
Right.
Let's see. And I think, maybe if we pull this one up, I think this is the family size chart. Take a look at this guy. Was this it? You think so? Yeah. EB-5 investor and family member.
Yeah.
Having a hard time scrolling here.
That's it.
Yeah. So Almost half and half, I guess. Oh, this is at the I-829 stage, which is interesting. Why it would change so dramatically.
I guess I'm wrong about family size, because that does not look like it's a 1 to 3.5 ratio. That does look like a 50-50 ratio. It's like almost a 1 to 1 to 1.5 ratio, like almost family
You
size.
know what it is, Greg? Is that this is representing snapshots in time of 829. So what this means is it's looking back all the way to the original I-526 filers and the investors. Where did they all come from? They're all single family or single child families out of China.
Right.
So, looking back, yeah. So representing today's numbers and today's filers, where, the actual aggregate investor counts from other countries is a lot higher in proportionality than China. Maybe that's where today's visa issuance and concurrent filing, getting a lot of India and other countries in there, larger family sizes. Maybe that's really where it's coming from. But the 829, looking back, that changes things a little bit.
Yeah. Good catch.
Yeah. So let's see. The other side of this, so they gave us a geographical map of where the regional centers are from. And this actually probably shouldn't be surprising to anyone. Vast majority of all the regional centers, that darkest blue spot in the entire map, California. Over, I guess is what indicating 100 plus regional centers active in California. What that also means that California is probably the home of regional center terminations as well. But then, quickly followed by New York. Looks like, New York is probably by far the second highest regional center count. And then Texas, Florida, and Washington. New Jersey follows after that as well. So any surprises here, Greg?
No, I mean, you go where the money is, and there's a lot of Chinese investors, and look at the Chinese population sizes in those two biggest states. It's pretty clear why they would want to invest there.
I think that's a good correlation. Extremely strong Chinese presence and Asia presence here in California and New York. Direct flights, big cities, good education. Probably not surprising there. Florida, though, they hold their own on the number of counts as far as regional centers go, and more stories there. So USCIS, got kind of busted by the GAO, where they're not collecting certain data. They had adjudicators, they had economists, they had lots of people that had forcefully spoke up and said, we can't find data because things that are electronified and or have fields in one database don't have corresponding fields in another. It just seems like a kind of a mess. Like what is the story back there on use of tech, and why are they still using paper? What is the GAO supposed to do here?
Oh man, where to start? So when I came in 2018, we were an office that was building and growing in size. We were taking on a lot of adjudicators to hit a backlog that was growing, and so that gave IPO the opportunity to hire me, along with it was our biggest growth bump for IPO. And during the time, you would just work with conventional wisdom within the office was basically the way you would operate. When the program's small enough, that's okay. You can talk to somebody. Hey, I'm looking at this situation. What do I do? And then as things grow, it's really tough to train people to all understand the level that the institutional knowledge. When I say that, I mean people who have been around forever that just pick up on things that can't necessarily be trained because it's not worth everybody's time to learn this minutia. But somebody has it, memorizes it, and the people that work at IPO are excellent at knowing how to figure things out and remembering situations that they've been through to be able to help each other out. So that interpersonal balance was crucial, and we saw a lot of that as I went in. I'm always asking people questions like, "Man, how do you know this? What did you do? How can I help people? Shouldn't we write this down?" And we were at the point where nobody had the time to write anything down.
Can we write this down?
I mean, it's true. And there was a management philosophy that you're just going to work faster by going out and getting the information than trying to find it and getting into the weeds and maybe not being able to get exactly what you need. So there was a lot of encouragement put on collaboration. And then we had a different manager who said, this is not how we do things in life. Like, we need to put things on the rails. We need to be organized. We need to do a better job writing things down and communicating the way we do things, and we need to update our training so everybody's on the same page, because systems don't really matter unless you're doing things the same way. I mean, systems help you organize, but in terms of making adjudicative decisions, if you're looking at it two different ways and you're just getting stuck there, the system's not good for anybody. We've been asking for scanning forever, and it's just a budget issue. It just comes down to the sheer volume of paper that needs to get scanned is ridiculous. So to convince USCIS there's a benefit, I would have argued that you're potentially cutting off billion-dollar fraud schemes by, spending $2-3 million on paper, and I can control F and find similar bank accounts. Maybe it's low priority. And now they're finally scanning 829 so that they can actually hire people outside of the DC area to go online and start to work these forms. But to made here, during this period of time, there were systems used to just do internal tracking on, what adjudicator A and FDNS officer B could share about a case, and you could look it up based on, certain biographical information or by the project or by whatever, right? And then you go in there and you can kind of look at stuff. and then make your own determination on how to adjudicate the case, whether or not you feel that there's fraud based on the information that you got from the communications with the FDNS officer, or whether or not you're just going to say, this is not credible. It stinks. I have reasons not to believe this. Now I'm going to do open source research, look for collaboration. Nope, that's inconsistent. All right. So now we're walking down the RFE path, at least, or worse. At that point, am I really tracking fraud when it's inconsistent? No, but there are indicators in there that I would see in similar projects, or coming from certain agents, or coming from, if you see some similarities in terms of where the file's coming from, now you can actually use that and say, I'm going to look at this and see if what I saw in file A exists in file B, and kind of just like repeat the same mechanics. So I'm treating them in a consistent way. But if I'm not there the next day and somebody else picks up that file, they don't have access to all of my information. That's why we try to put everything online. Not everything makes it online. A lot of it gets printed out on paper, gets put in the file, gets stashed away. And you may never know that there's any correlation between that filer and the attorney they use, or agent, or like whatever it is that you might think is connected, and the next file, unless you're in there actually working it. So systematically, it's kind of a failure when it comes to being able to promote consistency, look at adjudications with the same eyes across the board, with the same information available. And that's why when scanning does happen, to your point, I would be able to flag a series of files by collecting the information that's across the board on something that I want future adjudicators to know. And I can put it in the file or on part of a system in a more specific way. So the next person to pick it up doesn't need to have a conversation with Greg. The work is done. I think over time, things like that have been slowly developed, but it's almost impossible for it's not impossible. It wasn't the way it worked for IPO to say the fraud trend here is X. And now I'm going to find this in like a scroll down box, and then I'm going to mark it, and then we're going to capture the data that way. It just wasn't necessarily a priority. The work was do a good job and then do it again, right? And so in terms of tracking, I don't know if there was ever an initiative put forth by management to try to like track a certain style of fraud, where usually it's misrepresentation that leads to somebody trying to procure an immigration benefit based on being unlawful in what they're giving to the United States, which is different than just inconsistency through the whole thing because the attorney's no good, or because the petitioner is actually trying to do something shady.
Got it. Yeah, that makes all the sense in the world. So with the passing of the 2022 RIA policy, we get clients that are calling us, and we're all talking to them. One of the first things I'll ask is that I heard that EB-5 used to have fraud everywhere, and the program was broken. It didn't work. Now the new policy is here. What did the policy do in order to actually make EB-5 more safe? And in this GAL report, now they gave us a clear outline on the different departments that are involved. And they gave us several different agencies here that actually participate in the integrity of the program. There's DHS itself. Then there's the Department of State, the SEC, DOJ, and also the Treasury. So when investors are kind of asking, who's here to protect me? In your opinion, out of all of these contributors, how does the investor get integrity and investor protections? Like, who does what out of these groups?
A lot of that is related to a referral that goes outside of what you see in the file. I mean, if it's the FBI, is there money laundering, right? If it's Treasury, is there a tax issue? If it's DHS, is there a national security issue? So if it's SEC, is somebody unregistered, right, and doing bad stuff and taking, commissions based on successful leads, but not being a registered broker. So it really depends. I think that overall, the investor should be happy to know that with this report, there's a limited amount of actual fraud. But at the same time, my concern would be, just like you said, how are these people going to know that moving forward that problems won't happen again? And I think that you need to just kind of look at who you're working with. You need to look at people's involvement with the outcome of the project. So I think most of the problems that we've seen were indirect promoters or brokers who have no skin in the game. They don't care what happens. They're selling tickets to the game. They're introducing capital to a project. They're walking away. They're not answering their phone when the thing fails, or they're scraping a failed project off their website and moving forward as if nothing happened. I think for me, if I was going to be mentoring, if I had a family member who was pursuing EB-5, obviously I would have them talk to Behring, but realistically, if you're going to be shopping around, you have the weight of the government behind you in terms of the information they have. Most people don't get this. If you were to ask a regional center for all their filings, all the RFEs they've received, any notices of intent to terminate, copies of any amendments they filed, copies of their annuals, and they don't give it to you, meanwhile they want your money, they're probably going to say it's a really big file. And you can say 800K is the biggest decision of my life. If you have this information and you've given this to the government, why can't you give it to me? And I would be telling the SEC about that. And I would be telling IPO about that communication. And I would be telling the regional center that I don't like that answer. And I don't think it's lawful. And I don't think it's honest. And you're trying to get my money, but you're withholding information from me. This is a problem. And especially post RIA with more compliance requirements on regional centers to, deputize their projects, what they say to investors is going to be more actionable as well. So from that point of view, the investor should not go it alone. They should work with the government. They should make every step they can to try to get as much information from these people, because they are registered with the government. They're acting like broker dealers. They have compliance requirements, and USCIS will sanction people now. Once IPO got word that we could sanction people, man, the office was so excited. What does it mean? Don't really know on day one, but there's a path towards having that sanction power, which means when you're adjudicating these things and you see a problem, you feel like you have more power than just a denial. You're actually going to be able to not only refer, but to get some money back from the agency and protect investors.
Yeah, I mean that's real money.
Yeah.
So at that point, like that will really get people's attention with the power of sanctions and fines and all that kind of thing. And if it doesn't have their attention yet, it will.
Right.
So coming after people and the purse strings, that definitely is going to, for the investment community, it's going to make people perk up. The question though, is also are with some sort of sanction of a bad actor and a manager, a regional center sponsor or principal, are you really just punishing the investors themselves if you do that? Because like those dollar amounts, like where is that sponsor going to yank that money from?
Right. Yeah, exactly.
So there's a couple things where like it's going to be a little bit of a scorched earth policy if they do go after certain parties, and it'll be interesting to see how that plays out with those groups that do get in trouble. But I did want to pull up that one graphic where now all of a sudden we have a number, like here is the fraud and here is the national security. These are the cases, and obviously this is looking backward in time, right? If the case is closed and it's completed, how long did those items perpetuate before it actually became a closed case? What does 2016 really mean? Was it something that took place in 2012, 2011? How long does it take to get through the system? But even so, here's the numbers: 50 cases, 29, 56, 42, like with tens of thousands of filings, this number is minuscule.
But so, is that the percent of completed cases though? Like, isn't that 50%?
Maybe I can't read.
I haven't seen the slide. But, we can
well, percent of completed cases finding fraud. So a case gets opened, it's 3% or so of cases, or 3% of petitions are involved in a case. And then 50% in 2006. So like 1.5% of those petitions were actually found.
Exactly.
Okay, now we can do math. This is good.
Let's restart.
Restart. Yep, exactly. So so I guess looking at this table and its completed numbers, we'd say 3% of petitions were found to be involved in a case. 50% of those cases were actually found to have fraud. 2017, that number came down significantly. It's down in the 20s. Then it bounces around the 50s and 40s. And in 2020 and 21, it looks like the agencies just got better at opening cases because the number went up to 68 and 67.
Maybe, or Wolf hired enough FDNF officers, or the guy Cuccinelli maybe hired more people and they were able to actually do the work faster.
Yeah, very well could have been. But with 3% of petitions involved in a case, anywhere from 50 to 60% of those actually having fraud, they've got a 1/3, 2/3 hit rate. It means that fraud in EB-5 really comes down to about 1 to 1.5% of cases are involved in some sort of fraud or national security concern.
Right.
And with that, I mean, that's a low number. So if you look back to the EB-5 policy expiration and the whole political environment about why EB-5 needed to die, and there were certain senators and certain people out there that let the program expire because of rampant fraud. This report says that 1% to 1.5% of a $40 billion program was, somewhat involved in an issue.
Yeah, I'm sure Jim Jordan has a comment on this, but yeah, it's really like, it's not like we were sitting around there saying like, here's all these problems, like, wow, this is so bad. How can you do this? We're just shutting everything down. Like the high number of terminations was on inactivity. It wasn't on potential problems that were fraudulent. It was just, you're not doing anything, walk out. There's a systematic way to clean out the shelves. That happened. So when you see a fraudulent project and that can impact investors, then I think that the data it'd be interesting to look at, because if the project itself has a fraud issue, the petitioner may not, and their adjudication decision may be on a lack of job creation because the project failed for fraud reasons. If the petition denial wouldn't necessarily be based on fraud, it would just be job creation denial.
Yeah, we didn't talk about like CFIS and that kind of stuff, but like CFIS, it's really not an investor issue. It's a bank issue where, we spend, like the concern of CFIS and having some sort of foreign involvement or foreign threat, via an investment vehicle, the senior banks are always with foreign equity, which comes from EB-5 investors, are all international, non-U.S. citizens, and banks get all a little uptight about new CFIS requirements. CFIS, got expansive authorities. I believe it was 2018 or 2019 where CFIS was expanded significantly, and it became a concern because as a bank, if you were found to be involved with some sort of CFIS issue, theoretically they could just foreclose and take the whole investment and take control of it in custody. But even CFIS here was found to be a fraction, a minuscule, less than 1% of any sort of involvement. And that's not really surprising considering a typical EB-5 investment is not really in a sensitive industry category. It's in construction. So, in any sort of normal construction of any of the big food groups, whether it's residential, commercial office, hotels, those are typically not a CFIS category. It's not like semiconductors. It's not like lithium-ion batteries. It's not in a sensitive technology.
Right.
Not surprised to see CFIS play out in that realm there.
Yeah, I mean, if you're building a biotech plant next to a nuclear reactor, I think that's going to be pretty obvious that there's a problem here.
Right. Good stuff. Okay. Well, Greg, thank you for your insight. Thank you for reviewing thank you for reviewing the GAO report with us, and we'll look out for the next news bites that come out. But this is the group from Behring Co. Reporting live, and thank you very much.